Hello, everybody. Michelle McNall here with ABC Home Health Care Professionals, and I am here with Patrick Curley, an elder law attorney at Curley Law Firm in Wakefield. We have a lot to discuss today. He is a wealth of knowledge, and I just can't wait to get to all of the topics that we're going to discuss. But first and foremost, I want to hand the floor over to Patrick, one of my most trusted elder law attorneys that I work with and advisor. So without further ado, Patrick, can you tell us about yourself? And thank you so much for joining this morning.
Thank you, Michelle. Thank you for having me. It is a delight to be here. I have practiced law since 1997, and I got into this area of law, of elder law, because I saw what was happening with my own grandparents. And I saw the benefits where they had protected things and themselves, and I saw the disadvantages where they hadn't. And I knew that was the area of study I wanted to go into. I've now practiced just in this area of elder law and estate planning for more than 20 years. I'm in my 21st year now, and I'm also a certified elder law attorney. And there's just about 24 of us in Massachusetts, and it's a very difficult certification to achieve. So we're very proud about our exclusive focus in this area of law at our Curley Law Firm.
I certainly know that you take pride in everything that you do, having worked with you, for a number of years. You've helped some of my family members as well. So just thank you so much for everything that you do to help our clients and beyond. And so today I know that we want to talk about probate, right? That's a topic that a lot of people, they may know the word, but do they really know what it means? So let's just get started with the simple stuff. What is probate?
So as a general matter, probate is referred to the process after someone dies and the distribution of their property to their family or beneficiaries. What goes through probate are assets that are in the decedent's name alone that do not name a joint owner or a beneficiary or a transfer on death or payable on death. So if you think about life insurance, you'd often have a beneficiary listed. That would not typically go through probate. But if you think about a house, and if it was named in an individual's name alone and they died, that house has to go through probate. And what it really means is that the family has to go through the probate court process. There's a petition and a range of documents that have to be filed. If there's a will, the court can allow the will and appoint the personal representative, which is a term for the person who's going to manage the process. That term used to be known as an executor or executrix, now known as a personal representative of the estate. And so it's this court process known as probate for assets owned by the decedent alone.
And so when we refer to the court process, the probate court process, how long does that usually take?
So at a minimum, by statute, it takes a year. And the reason is that creditors of the decedent, those who might be owed money, whether it's a credit card company or the next door neighbor who shoveled their driveway, they have 1 year from the date of death to make claims against the estate. So at a minimum, you're talking 1 year. But what you often find, Michelle, is that when there's complexities and when people die, guess what? There's complexities. It can drag on. People can argue. There can be fighting over property. And when there's real estate, there can be title issues. We have seen probate sometimes brought to our office by families in tears, begging us to fix things, not our cases, and we'll take it on. But sometimes these cases have gone on for many years in the probate court.
Wow, okay, that's really eye-opening because I knew that it was a lengthy process. I just didn't know exactly how long. So what requires probate and then what bypasses probate?
Well, the items that would require going through probate, again, are those items that are owned by the decedent alone. There's a bank account in their name alone, or a piece of real estate or stock. It's stuck in their name. It cannot pass on to beneficiaries until a probate is completed. What can bypass property can be items that are jointly owned, where someone else is surviving the decedent, or there's a beneficiary like life insurance, or where the property is owned in trust while the individual is alive, and upon their death, the trust controls how that property passes and to whom it passes as dictated by the trust.
Okay, and so obviously probate is a long process, but are there any other benefits in avoiding probate?
Well, I think there's a number of benefits to avoiding probate. Because we live in a very technological society, when you go to probate, it's very public. People can log into the court website and discover a lot of information about the decedent, their finances, their will, their testamentary wishes, the beneficiaries identifying information. And so if you think about financial predators, you read about this fraud and predators in the paper. The idea of keeping all of that private is very appealing. And of course, when you avoid probate, you can simplify the process of estate administration. You can reduce the time frame of estate administration. You can more carefully protect inheritances if a beneficiary is maybe disabled or a minor. And by avoiding probate, particularly when you are using a trust. So there's quite a few reasons why folks might want to avoid probate. And as my dad taught me, and my dad, Mark Curley, was my law partner for many, many years, for almost 20 years. He retired in 2021, but he taught me that when clients have to go to the probate court, it's like those old cash registers, ka-ching, ka-ching, ka-ching. The court charges fees. There's, maybe service fees, publishing fees, constable fees, lawyer fees. All of these things add up and the costs increase. And so that's something that folks have to consider if they're going through probate or they wish to avoid probate.
You don't think about all the costs that are really associated with that. So that is a really good point. So to that point, how can one avoid probate?
Well, what we tell clients is we think that a trust is the best method to avoid probate. It gives clients the most flexibility, the most control, and the most opportunities to ensure that their estate and their assets pass exactly per their wishes to the beneficiaries of their choosing in the most efficient way. And so creating a trust is the first step. But there's no one-size-fits-all trust. And so a trust is only as good as the words drafted in it. So it's vital that individuals go to an attorney with deep experience in trust drafting. And another element of experience that's valuable is tax experience, because all of us have to deal with taxes, whether it's income, capital gains tax, or even the estate tax in Massachusetts. And so you want to have your attorney have considerable specialization in tax planning when creating a trust as well, because the last thing you want to do is you or your estate to pay more in taxes, or your beneficiaries to pay more in taxes. And so the primary advice we offer would be to tell people they should consider a trust by talking with a qualified attorney. There are other couple of strategies sometimes people will use, including joint ownership. So they might say, well, look, I've got 3 bank accounts and I've got 3 children. I'll make one account for one child, one for the other, and one for the third. The problem, and there's a number of problems with that. One of them would be, what if the joint owner gets in a car accident and gets hurt? And they might think, well, I've got great insurance. Well, the insurance might couple 200, maybe it covers $250,000. But if the individual who's harmed is really harmed, and they learn that you are the joint owner on mom's account, they're going to shoot for the moon and try to take mom's account. And if mom goes into that lawsuit with this personal injury lawsuit, and she's got tears in her eyes telling the judge, look, this is really my account, the judge's hands are tied. The child's name is on the account. So there's considerable risks with joint ownership, particularly for larger valued assets and accounts.
Wow, yeah, I didn't even think about that. So it really is important that when clients are going to you, in order to make the most of their time with you and the most of their experience and getting the right trust, because like you said, it's not a one size fits all, right? So people need to be completely forthcoming and honest with you and how they want things done so that you, in turn, can draft up the trust accordingly. Is that correct?
That's absolutely right. Our goal is to serve the goals of our clients, to talk to them about the key issues and for them to make an informed decision. We present the options in a way that they understand. We don't like to use legalese that confuses people, and then they help design it so it matches their wishes. One vital point, Michelle, many attorneys will draft a trust, charge their fee, and say goodbye to the client. Now you've got a trust, and I like to think of it as a bucket, right? A trust can hold things, including accounts or real estate, but it's empty. The bucket's empty. And then the client dies, and they think they and their family have thought that everything was in the trust and it's going to avoid probate. And it turns out that the lawyer never helped the family or advised them to put things in the trust while they were alive. So they pass away, and guess what? They have to do a probate. They've got to go through the whole probate court to then get things into the trust. So if you create a trust, or if a listener or viewer on this podcast has a trust, be sure that you think about, how is my real estate owned today? How are my accounts owned today? How are my CDs owned? Are they in a trust? And if you have any questions, go back to your lawyer that drafted the trust to make sure, or see an attorney who has real specialization in this area of law, and they can
Excellent.
guide you.
So I was gonna say, so what type of accounts should be in a trust? So it's obviously any real estate, it's bank accounts. Does anything like life insurance policies and things like that apply to a trust or no?
The answer, Michelle, is it depends. It really depends. And so I cannot simply say everyone should put everything in a trust. There's strategy to this, particularly when it comes to other types of assets like life insurance or qualified retirement accounts. Those have to be named in the decedent's name. But then the question is, who do you name as beneficiary, the trust or the individuals? And there's a lot of complexity. It's vital that viewers talk to a qualified elder law attorney about their situation, because in this talk with you, I'm not giving legal advice, I'm just giving you general information. But people really need to consult a qualified elder law attorney to find out, based on their circumstances, their goals, what is the best fit for them.
We've talked about, kind of why we want to avoid probate. Are there any benefits to going through probate?
There is one that is particularly interesting, and it's not well known by many attorneys. And that is that we do a lot of asset protection planning. And what that means is our clients have worked their tails off all their lives. They've got a house, maybe some accounts they've saved. They're not rich, but they're concerned about long-term care. What if we get sick? Can we protect some of our assets? And one of the strategies that we use, particularly for married clients, involves engaging in a probate after the first spouse's death, because it allows us to shelter assets under federal law for the surviving spouse. And so even though we'd love to avoid probate, there's a benefit in doing it after the first spouse's death if we can set up the will and trust correctly, because it can shelter assets for the surviving spouse. Even if they're sick or they get sick in the future, the Medicaid Mass Health Agency can't reach in and get those protected assets if it's designed correctly under federal law. It's vital that individuals see an attorney who really does this day in and day out, because people can obviously get caught. If they make a mistake, it's on them. So it has to be done correctly.
And so I know that when we talk to certain clients and they're thinking about, okay, yeah, I want to get my affairs in order, I want to set up a trust, but they're concerned about pricing, right? Because a lot of people are on fixed incomes, they're retired, so they're nervous about that. And one of the things that you and I have always talked about is, you have to think of it, it's not a cost. It's an investment, right? So can you talk about that? Because you've said that before and it resonates with me 1,000%.
Right. So this is an investment. You're talking about your nest egg, your life, your independence. How can you say that's not worth spending the time and money and investment to help protect it and plan for it? And too often people think, I'm just going to do a simple plan. And for a simple plan to succeed, everything has to go right. But you and I both know that life is full of curveballs. And you want your plan to be ready for curveballs. And so the cost, the investment of doing estate planning varies based on the complexity. And different attorneys charge different amounts in different ways. What I tell people is the best value you can get is talk to a lawyer who really knows their stuff and at least learn the information so you can make an informed decision. Whether you move forward with that attorney or not, learn what the facts are, because too often people rely on family or friends and they don't know the actual legal issues and legal facts. And the other thing I'd say is that people should not focus solely on their death and probate and wills and trusts. They have to plan for their lifetime. And one of the ways they can do that is if they have a need for added care, they should get the care they need. And outfits like ABC Home Health Care can come in and provide care. And I know that sounds like a plug for ABC, but it is. It's these outfits can provide care to help keep you in a home or wherever you may be so that you don't need Mass Health or Medicaid. And the best advantage you have is to be independent and as healthy and well as best you can. So don't sacrifice your needs thinking I got to save it all for the end, because you might end up in a much worse situation. And I always tell people, invest that money. The nest egg is there for you to care for yourself. I'm an elder law attorney. My client is always the elder, not the kids. And I know that's the same for obviously your organization as well.
You said it perfectly. Your money is there. You worked that hard for yourself. So when you need the care, just get it. Get the care that you need so that you can live with dignity, so that you can live, whether it's in your home or, with a family member or friend or in an assisted living, wherever you call home and you need the care, you owe it to yourself to be able to do that. And thank you so much for the kind words. We obviously really appreciate it. And as you know, all of us that are in this elder care industry, we're in it because we are passionate about what we do. Well, thank you so much, Patrick. I know we're hitting about our time, and we really covered a lot in a short amount of time, which is great, but we really have only scratched the surface. So what I'm going to do right now is tell everybody who is watching, first off, thank you so much for tuning in. We appreciate it. And second of all, if any of this has resonated with you, if you're curious to learn more, you can obviously reach out to ABC and we'll pass you along to Patrick, but reach out to Curley Law Firm directly. Patrick and his amazing team will guide you through the entire process. Just go see the professional.
Thank you, Michelle, for having me. This was a real pleasure.
Awesome. Well, thank you, Patrick, and we will work together real soon.
Great. Bye-bye.
Thank you.
ABC Home Health Care, committed to life at home.
Call 781-245-1880.